All rise. Hear ye, hear ye, hear ye. The Supreme Court of the State of Michigan is now in session. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Well, welcome. I'm Bob Young. I'm the Chief Justice of the Michigan Supreme Court. And on behalf of the court, I want to welcome you here to this program to reach out to take the court on the road. And so before I call today's case, I'd like to take a few moments to thank our hosts and welcome all of the area students and educators. As some of you know, one of the members of our court, Justice Bridget McCormick, my nemesis, lives in Ann Arbor.
That means it in a good way.
I do, in a good nemesis. Lives in Ann Arbor with her children, who are students here at Pioneer, and refused to throw her under the bus, even though I asked repeatedly for information I could use. She has told me that it is her intention to embarrass her children, which usually is not a hard feat for any parent who has children of adolescent age. And now I've got to get my papers in order. Hopefully they're... Justice McCormick tells me that Pioneer is the best high school in the state and a school that has many achievements ranging from Nobel Prize winners to Grammy winners. That's indeed remarkable. However, I think there are some dissenting opinions in the room. This also marks the first time that Justice Richard Bernstein will be with us for a Court Community Connections program. Justice Bernstein was an undergraduate at the University of Michigan. So he's very familiar with this community. And thanks also to the Bar Association attorneys and to the attorneys who will argue this case, Matthew Kakulak and Mark Donnelly. Students in the courtroom represent community, Huron Pioneer, Skyline Schools from Ann Arbor, plus Dexter, Milan, Saline, True North, Washtenaw International, and Whitmore Lake High Schools. We want to recognize and congratulate the Ann Arbor Community High School students for winning the recent mock trial tournament in Lansing. The state champions will advance to the national championship in Raleigh, North Carolina, and we wish them the very best in their May competition. I'd also like to highlight the achievements of Pioneer history and social studies teacher Jim Robert, who was one of the 3 Michigan educators recently honored by the John F. Kennedy Center for the Performing Arts for being the source of inspiration to our students. And now a couple of housekeeping items. With the exception of the media and professional photographers, we ask that no one take photos once the oral argument begins. And this is important for both counsel and the court so that we minimize distractions. There will be plenty of opportunities for photos during the reception. Also, if you have not done so, please turn off all your cell phones and other communication devices or put them on stun for the remainder of the proceedings. Now, following oral argument, please remain in the courtroom for the debriefing with counsel for the parties, and Joseph Bauman, our State Supreme Court General Counsel, will moderate that discussion. Court Community Connections is created to give you an up-close look at your Supreme Court. We often have school groups come to Lansing to see the court in action, but today we have come to you. Oral argument is a key part of the appellate decision-making process and can determine not only the outcome of the case for the parties, but it can affect the outcome of future cases that the lower courts are bound to follow. So by the time of oral argument, the justices are very familiar with the case. We've read the parties' briefs and the applicable lower court record, and we've studied the legal issues. And the questions we ask during oral argument and the counsel's answers do help us reach a decision. But more important, they help us, if we render an opinion in the case, to craft an accurate, clear statement of the law. Like us, you've studied the case, you know what the issues are, and you come to the hearing today with questions you would ask if you were sitting here with us. So sometime now from now, if we issue a decision, you'll get to analyze our ruling and decide whether you agree or disagree with what we've done or whether you have done differently. So our goal is to leave you better informed about the rule of law and its role in our constitutional republic. And my hope is that as a citizen of your community, you will remember this experience. Our form of government can only survive if you, its citizens, are informed. So with that, I will call the case. State of Beals versus State.
Good afternoon, Mr. Chief Justice Young and Justices of the Supreme Court. May it please the Court, I am Assistant Attorney General Mark Donnelly, and I am appearing on behalf of the appellant, William Harmon. With me at counsel table is Assistant Attorney General Joseph Freilich. And despite images of the Roman Colosseum kind of dancing through my head, let me say it's an honor to be here, and it's a privilege to be able to participate in the court's community outreach program. I would like to reserve 2 minutes of time for rebuttal, and I do understand there's no light system, but a bell will alarm at the 2-minute mark.
I think it's in front of you.
Those little lights.
They're apparently not working today.
Oh, never mind.
So thank you. Because the Court of Appeals misapplied the plain language of MCL 691.14072C and misapplied this court's ruling in Robinson versus the City of Detroit, we request that this court grant our application for leave and hold as a matter of law that William Harmon's conduct was not the proximate cause of the death of William Beals. Harmon's dereliction of duty, assumed dereliction of duty for purposes of this record, and his failure to intercede or rescue Mr. Beals was not the most immediate, efficient, and direct cause of Beals' death. For this court to hold otherwise, it would run contrary to the court's order in Dean versus Childs, which adopted Judge Griffin's dissent in that case. In Dean, the cause of the death was the fire, not the firefighters' inability to battle the fire.
Counsel, good morning, and thank you so much for coming. I was jumping in here just because as I did my analysis of this case, first off, thank you for coming to the court, and we're delighted to be with everyone here today at Ann Arbor Pioneer. I'd like to focus on the word most in terms of the definitional statutory construction that we're finding under Robinson. Is it fair to say that, as we look at the facts of this case, that the young man who has died is autistic, correct?
There is some suggestion in the record that Mr. Beals had some form of autism. However, it was not developed or supported by record evidence in response to discovery.
But this facility is designed to be a residential home for a residential place for folks with disabilities, correct?
That's correct, Your Honor.
Okay, but for the fact that the lifeguard was on duty, would they allow for people to swim without a lifeguard?
Well, I don't know the answer to that. That wasn't developed in the record. However, as Your Honor, I'm sure is aware, there are many levels of disabilities. Disabilities, of course, are not all created equal. So,
And the child disappeared for 8 minutes, though, correct?
Mr. Beals was underwater for approximately 8 minutes before any of the 25 people in the pool noticed him underwater.
Right, and he was noticed not by the lifeguard, but he was noticed by another swimmer.
He was noticed by another swimmer who was diving for coins.
Right, because he was not at the lifeguard station, correct?
He was not at the lifeguard station. There was some, but he was, if the video depicts Mr. Harmon walking around the pool area, but he was not seated in the stationary lifeguard chair. So in respect to you, following up on your questions, Justice Bernstein, there's no evidence in the record that the reason for Mr. Beals being in the water had anything to do with what William Harmon did or did not do. In other words, William Harmon didn't ask him to come into the water. William Harmon wasn't supervising him in the water in terms of any differently than anybody else in the pool. He wasn't on...
He's the lifeguard, though, correct?
He is the lifeguard, Your Honor.
And again, you weren't able to answer or clarify my original question, which was, for a facility that deals and caters to the safety and well-being of people with disabilities, you weren't able to clarify the question as to would they allow for such activities to take place but for the role of the lifeguard?
Well, I think that the school has a policy that when there is open swim, there are lifeguards. I don't think that changes the dynamics with respect to the liability of Mr. Harmon personally, because there's nothing in the record to suggest that Beals would not have entered the water but for Harmon being on duty as a lifeguard. I think common sense and common experience tells us that an adult who in this case, the facts of this case is that we have an adult who might have had a mild form of autism, who was known to be an accomplished swimmer according to his family. There's nothing in this record to suggest that he entered the pool because of any inducement or because of any sense of security that he had because Harmon was there.
But let's not go down that line. Let's go back to Dean versus Childs. And I think that this really dovetails on Justice Bernstein's question regarding most. And I think you're right to focus on Dean versus Childs and the firefighter's case. Because a lifeguard is like a firefighter in that we've got the harm, here we have water, not a fire, right?
Correct.
And so the lifeguard's obligation is what? Is to save a person who's in harm's way, correct?
That's correct.
And so here, the death occurred because of a drowning, right?
Correct.
Now, the question is whether the proximate cause of the lifeguard not attending to his duty was the proximate cause. Is that right?
That is the issue before the court.
And Justice Bernstein wanted to know if the word most was significant. My question to you is a little bit different. My question is, in cases like this, like in Dean versus Childs, where we have harm's way, water or fire, and where we have a government agent, a firefighter, or a lifeguard who has an obligation to step into harm's way, can there be more than one proximate cause?
My belief is that there oftentimes are more than one proximate cause, and that's clear. But the focus has to be, was the government actor's conduct the one most immediate, efficient, and direct cause?
Okay, let's just stop right there. Why do you argue that there has to be one proximate cause?
Because that's what the statute says, and that's what this court said in Robinson. In order to hold a government actor liable, his gross negligence, his or her gross negligence, has to be that one thing more than any other that caused the injury, and in this case, resulting in death. So in this case...
Okay, but again, I want to focus on those cases where we've got harm's way, the exigent circumstances of water or fire, and Dean versus Child, okay? So in those cases, can there be more than one proximate cause?
Certainly. For example, even in Dean versus Child, Judge Griffin in his dissent acknowledged that the gross negligence of Mr. Childs could have been a proximate cause of the injury, but it was not the proximate cause of the injury because it was not that one thing more than any other that caused the deaths. And so too here, the conduct of Harmon in not paying attention or not observing or not seeing Mr. Beals underwater may have been a proximate cause because he may have been able to rescue him had he noticed him. But that's uncertain, and it's not enough to establish.
But counsel, immediate, efficient, and direct is how most is defined under Robinson. So using that statutory construction in this situation, we have two issues. We have the definition of most, but we also have the question is, do you believe that it's fair that the question here is, can reasonable minds determine whether or not this was the proximate cause under the definition of Robinson? Is it your contention that no reasonable mind could determine whether or not this was the proximate cause as based off of the facts in Robinson?
Well, I would answer that question. I don't think any reasonable mind could, but moreover, I don't think it is a question for the jury. Proximate cause is a question of law for the court. And this court found in Robinson, as a matter of fact, in Robinson versus City of Detroit, this court held as a matter of law that the proximate cause of the injuries or death in Robinson was not the police officers, but the fleeing suspect.
Let me see if I can frame the legal questions here a little differently. It strikes me that in a number of the unpublished Court of Appeals cases, I think one of which might have involved a lifeguard, there was a great deal of focus on the breach of the duty, statutory duty of a lifeguard. And it strikes me that those cases seem to conflate the breach of the duty with the causation analysis. And so I want to put to you this question. Given your belief about how the Robinson construction of this statute should be read, can the proximate cause ever be the failure to perform if the injury is already in motion?
I could not think of an example where that would be the case. I think once that, unless somehow the causation is broken, and then a new cause comes in, I don't see how it could happen. And
so let me just press you just a little bit further. So you believe that in this case, the only way the lifeguard could have been the proximate cause is if he had pushed the decedent into the water?
If he had pushed him into the water or otherwise induced him into the water. And let me give an example, and maybe this will, for Justice Bernstein as well, is taken from my own personal life. I have a severely disabled 16-year-old son. And he goes to a special school, and they go swimming. But he would never go into the water. He would never be able to make a choice to go into the water by himself. He is taken into the water by a special aid with one-on-one, so on and so forth. In that case, if something were to happen to my son, potentially an argument could be made that something that aide who brought him to the water, who put him in the water, and who was with him in the water, failed, there was some gross negligence that might have been the proximate cause. That's what we don't have here.
You're under 2 minutes. Do you want to reserve any time?
If I could, Your Honor.
Now's
Thank
the
you.
time then.
May it please the Court, I'm Matt Klikulik on behalf of Plaintiff Appellee Teresa Beals, who is the personal representative of the estate of her deceased son, William Beals. And to jump right in to Justice Young's line of questioning, defense has argued in their briefing that omissive conduct or failure to rescue or failure to act to save a person in distress when you have an affirmative obligation to do so can never be the proximate cause of the injury and actionable. And the language of 691-1407-2 does not preclude such conduct from being actionable. The definition of the proximate cause from Robinson v. City of Detroit does not preclude such conduct from being actionable. The legislature could have made only affirmative conduct actionable, but it did not do so when it drafted the statute, and this court should not step into that legislative role. Defendants argue that water is the proximate cause, and it would blame the actual physical mechanism of injury as opposed to the conduct that brought that injury forth or put it into play or allowed it to continue. But doing that would lead to 1407-2 essentially being a nullity, because you can always say, well, the ultimate cause of death was lack of oxygen to the brain, or I'm going to blame the bullet and not the reckless conduct of the government actor who fired the gun. And it's a fundamental rule of statutory construction in Michigan that you don't read a statute and not provide meaning to any phrase or word in it. They intended every word and phrase to have meaning. People rely on the presence of a certified lifeguard to act for their aquatic safety. The people who are attending this student swim at the MCTI school knew that there was a certified lifeguard on duty who had a duty to sit there and watch and scan the pool for signs of distress and to respond timely in the event that there was distress was evident to them. And this is a reason for the gross negligent failure to perform such duties to be deemed a proximate cause of the resultant death.
Counsel.
Yes, sir.
I think I want to try and focus. This is a very emotional case. A child has died, or a young man has died, rather. And so that can cloud a lot of things. So I want us to try and put aside the tragedy of this case and focus on something. You've said that reading the statute as though there is, not a continuum of causes would make it a nullity. I mean, I think what Robinson did was say there is a continuum of causes. In that case, it was a police chase of a fleeing felon who in turn hit an innocent bystander. And under the existing law before Robinson, the cops, who were governmental agents, would have been held liable for the injury to the innocent pedestrian there, because they were a proximate cause. What Robinson said is, yes, they are a proximate cause, but the statute requires them that they be the proximate cause for them to be liable. So that meant there was a more direct cause. That's the car that hit the pedestrian. And so what we're trying to figure out here is the fact that the lifeguard did not save this individual can be a proximate cause of the death. So we're really asking, is that the most direct cause? Not a cause, but the most direct. And explain to me, therefore, given Dean, which is a kind of a similar fact pattern, we have people in peril by an independent danger, fire. We have people with a duty to extinguish the fire and protect the people, and it was argued there that they were negligent, grossly so. But the statute requires that they be the direct cause, not a one of many. So how do you distinguish Dean? How is the lifeguard unlike the fireman, the grossly negligent fireman, and Dean, who didn't properly extinguish the fire and the people perished?
Yes, Justice Young. I think that the fire cases are distinguished from these drowning cases, and there are other Court of Appeals decisions, Avery v. Roberts and Ray, State of Anderson, that also were allowed to survive summary disposition.
Yeah, but I think they conflated the breach of the duty. They mixed the causation analysis, and that's what I'm trying to keep separate here. There's conceded here, there's a breach of the duty.
Well, I think
That's not the same thing as saying that that is the cause.
the distinction between this drowning case and Dean v. Childs is that here there was an on-duty lifeguard who was watching the pool, scanning the pool, looking for signs of distress before any event arose that required him to respond to it. And for Dean to be comparative, you would have to have had a firefighter sitting across the street from where the house was, and his job was to sit there and watch that house and make sure that no fires were started, and then upon the fire being started, to then rush in and stop it. That's not the scenario that firefighters are presented with. It's a completely different thing where they are made to go to the scene of an active, ongoing emergency right in the midst of it versus in a lifeguard scenario where you're sitting there watching the situation develop and you're supposed to act preventatively and not only to act
But that's duty.
preventatively.
That goes, if you're supposed to act preventively, that goes to the duty, right? That's not necessarily, you have to explain to me why the failure to act, even if you have a duty to act, translates into the proximate cause.
Well, also in this case, the uncontested gross negligent conduct of William Harmon, the lifeguard, was the last significant link in the chain of events.
True. Okay.
And it was
That's
the final
a
and
proximate
decisive
cause.
factor producing the injury because he had an opportunity to intervene and
Counsel,
rescue him and resuscitate
Let
him.
me jump in, because you referenced that the lifeguard's job is to look for signs of distress in the water, and I would agree with you on that point. But the facts of this case, as I understand them, based on the video, are that this person who drowned was, I think, what your expert would refer to as a passive drowner. He did what they call a surface dive into the water and then swam to the deep end of the pool. And so it appears from the record that there were no signs of distress. And I'm just wondering how, as you mentioned, based on what I think could go to duty and causation, that this issue of whether there were signs of distress, how should that factor into our analysis?
Yes, Justice Viviano, I don't know if you had the opportunity to look at that DVD, but the resolution of it is extremely poor, and you really can't tell what's going on at the deep end of the pool where Mr. Beals was recovered. So there's actually, it's
But
still...
there was some testimony that he was at the bottom, close to the wall.
That's correct.
In a position that would be difficult to be viewed from the outside the pool, right?
And the preliminary expert witness report of Gerald Dworkin, our aquatic safety and rescue expert, indicates that had Mr. Harmon been sitting in the elevated lifeguard chair, which is recommended by the American Red Cross, that they do, and been scanning the pool, that he would have observed Mr. Beals at the bottom of the pool and would have been able to
The
intervene.
point that Justice Viviano was pointing out is there was apparently no one testified that there was thrashing or distress that might have caused any of the 25 people to realize somebody was in trouble. Isn't that true?
And I guess just to further the
It's
point,
not clear from the
there's a little bit of a disconnect, because your expert, he did say that in the preliminary report, and I understand it's preliminary, but he also, in the sort of the generic part of the report where he describes different ways that people drown, describes something that sounds a lot like what happened here, the passive drowning. So I guess on the one, I want to know two things. Do you agree that this was a passive drowning situation? And if so, does the fact that there were no signs of distress, how should that factor into our analysis?
I don't agree that it was necessarily a passive drowning because the video record is not clear, but I agree that there is not direct evidence in the record of his thrashing about. However, I don't think that precludes the gross negligence of William Harmon being found the proximate cause here because, as Gerald Dworkin indicated in his expert report, he was not in an elevated lifeguard chair scanning the pool for signs of distress or he would have seen William Beals at the bottom of the pool prior to the other student who was swimming, Matthew Brenningstall, seeing him and pulling him out himself. And furthermore, when Matthew Brenningstall saw him at the bottom of the pool, he yelled out to the lifeguard repeatedly, and the lifeguard was not paying attention, and it wasn't until he was brought to the surface that he actually attended to him.
I agree with you, this lifeguard was not, in any sense of the word, doing what a lifeguard was supposed to do. But again, from the video, we know at that point this unfortunate incident had occurred, and this young man had been in the water for something like 8 minutes, right?
Correct, at least 8 minutes. And I think my point is that the swimmers at the pool are going to foreseeably rely on a certified lifeguard being there, and their conduct is going to be different based on that certified lifeguard being there versus a certified lifeguard not being in attendance at the pool. And in fact, they may not even have attended the student swim had there not been somebody there to watch them. And I made an analogy in my supplemental brief that I think pretty aptly describes why the gross negligence should be deemed the proximate cause and not the water, as defendants contend. And that was an analogy between the lifeguard and the swimmer and a rock climber and a belayer. And a belayer holds the rope that then goes to the top of the wall and goes to the harness of the rock climber, and their obligation is to keep the rope taut, and in the event that the rock climber slips and falls, you create pressure on the rope to keep them from falling down and injuring themselves.
It's more like
And
the
that's-
relationship that counsel mentioned exists with his child and the person who assists him in the water than it is somebody who is independently swimming and a lifeguard who's standing or sitting somewhere on the side, isn't it?
While I grant you that analogy is not a one-to-one scenario, it's
Well,
nonetheless...
it's a lot different, because a belayer is literally tied to a climber.
I love hypotheticals. I'm usually the one, like, sometimes crazy hypotheticals help us figure out where the lines are, so I actually usually love them, but I'd actually like to just move back to lifeguards if we could. And you've been talking plenty, so it's my turn. I'm just kidding. This is a case where the facts are not in dispute, so I don't even want to spend too much time on that. Can you tell me, because I come to Robinson, new. I'm only on this court 2.5 years. I read it. I'm trying to make sense of what the standard means, what one most immediate, efficient, and direct cause is. And I could imagine, at least in my head, some cases where it's easy to say the lifeguard's gross negligence was that, and other cases where it's easy to say the lifeguard's gross negligence was not that. It seems to me there are possibilities in both. Can you give me an example of a case where you would say we can't say that the lifeguard's conduct was the most direct cause of the injury?
If they're grossly negligent?
Yeah. We're assuming I'm putting aside the duty, and we're just talking about causation. Or do you think the lifeguard is always going to be on the hook for causation because it's a lifeguard's job to stop somebody from drowning?
No, Your Honor. I'm not saying that would always be the case. I'm dealing and most interested, obviously, in the facts of this case before me.
I know, but
and I
we're
understand
not
that your role is to look at
interested in
This is the next
overarching
1,000
policy.
cases of drowning.
Yes, Your Honor. And I do recall an unpublished decision of the Court of Appeals that this court reversed. The name escapes me. I'm thinking it's Turner, where there was a drowning at a wave pool, and the person was removed from the pool, and there was a really haphazard and we contested a grossly negligent response to providing him with CPR or an AED usage or bringing emergency personnel or calling 911. And we contested that was grossly negligent conduct, that was the proximate cause. And they said that...
Counsel, do you feel that the fact that this is...
Come on,
Oh, I'm
let him-
sorry.
He was trying to answer my question.
Oh, okay. I just want to make sure we don't run out of time.
They said
keep talking, you're in
that
charge.
first of all, that his efforts were not grossly negligent, but that also that the mechanism of death was already enough underway that there couldn't have been it couldn't have been stopped by the time that they reached him here.
So the
And we have a
negligence was
question of
not
fact
the
from Gerald
proximate
Dworkin's.
cause.
We have a question of fact from Gerald Dworkin's expert report saying that had he noticed him earlier, as he could have had he been paying attention, that there was a window of opportunity for resuscitation.
Okay, so without a specific example, would you agree with me that there probably is some hypothetical out there where you would say that the lifeguard's gross negligence was still not the proximate cause of the death?
I do. I think
Okay.
that that's a very fact-specific inquiry.
Okay.
And that on our facts, we have enough.
You're there. Got
And
it.
I'm grateful that we let
I'm
you
sorry
finish
I cut you off.
No, actually, I'm very grateful that you finished the question. So I'm glad that Justice McCormick interjected that, because I think that was helpful, that your answer was very, very helpful, because it allows me to dovetail to this next question. And based off what the Chief was saying, he was saying that we're looking at the next 1,000 cases that come up. Explain to me what role you feel the fact that this was a program designed for special needs people, to set special needs folks who have disabilities. Explain to me what role you feel the fact that this young man had autism and possibly wasn't communicative. Explain to me what role that would have as it pertains to how this court should interpret this case.
Actually, I don't believe that there was any more supervision provided at this pool, this public pool, than would be required at any public pool than at this high school, for example, for a public swim, that in any public school scenario you would have to have a certified lifeguard on duty, and that there's a certain threshold for a number of people in the pool where you then need to bring in another lifeguard to assist them. We had a case where a companion case here where we contested that there was a violation of the Persons with Disabilities Civil Rights Act based on the number of lifeguards that were present versus at the student swim where all the students are disabled versus at a public swim where there are members of the general public who are not. And we lost on that in the Court of Appeals and did not pursue that here. But so with regard to this case, just because it's a public facility, under the Michigan Administrative Code, they're obliged to have a certified lifeguard on duty who is then obliged to not engage in conduct that would distract him from his attention to the pool occupants and from being able to respond expeditiously to any sort of emergency or circumstance that would arise.
Counsel, if I understand opposing counsel's argument, he indicated that there is no evidence in this case that there's any but-for connection between the plaintiff being in the water and the presence of the lifeguard. Do you agree with that?
Yes. Again, I'm going back to the fact that there is a certified lifeguard on duty and that people know and see that and would foreseeably rely upon their presence in them performing their duty.
Well, does that constitute the kind of but-for connection that I think opposing counsel is referencing here? A but-for relationship, I think, requires something more than the serendipitousness of there sometimes being a lifeguard present and sometimes not being a lifeguard present. Was it a precondition to Mr. Beals being in the water, either a precondition on the part of himself, his parents, or the educational facility, that there be a lifeguard present at the time, at every moment that he's engaged in the pool?
That's my understanding, Justice Markman, under, again, Rule 325.2198 of the Michigan Administrative Code, is that when you have a student swim like this at a public facility, you have to have a certified lifeguard on duty.
Opposing counsel seems to think that issue is relevant. Do you think it's relevant?
I do think that the presence of the lifeguard is relevant. I'm sorry I may not be understanding your question. I think that he foreseeably relied upon that lifeguard's presence and would have acted and would have conducted himself differently had there not been a lifeguard present. Or at least I think that viewing the evidence in the light most favorable to the plaintiff and with all reasonable inferences in the plaintiff's favor is an inference that can be reasonably drawn.
One last question. So we're focused on the facts of this case. We're focused on the duties of a lifeguard. Here we don't have any intervention, right? We've got what you considered passive. We've got passive indifference. That was the term you used. Passive indifference of the lifeguard, right? So how could...
Complete distraction.
Complete distraction. The video demonstrated that. Talking to girls and playing with a ball, right? Mm-hmm. So how could there be negligence if we don't have it here? How could there ever be negligence in a lifeguard case? Answer that question.
I absolutely agree with you. I'm not
suggesting an answer. I'm asking a question.
Have they not conceded gross negligence here?
They didn't contest it. They didn't move for C7 summary disposition on that basis.
So that's not even an issue.
Well, let's given that fact, go to proximate cause. Again, the issue of two proximate causes. Make your argument for how can there be more than one proximate cause?
Because what we need here to survive summary disposition under Robinson v. City of Detroit and its progeny is the one most immediate, efficient, and direct cause. And looking to the water or looking to his decision to go swimming, that's pushing the focus back up the causative chain from what was the final and decisive factor producing the injury, which was the gross negligence of the lifeguard here. I would like to point out some language.
That wasn't Justice Kelly's question, as I understood it. It was, can there be multiple proximate causes? I understand you think that there was a different proximate cause than opposing counsel thinks, but Can there be multiple proximate causes?
Absolutely.
Can there be more than the proximate cause?
Sure, there are many different factors that will contribute
In
to an injury.
Robinson, the mother lode, cop car decides to chase. Felon decides to flee, hits the pedestrian. The decision to chase is a proximate cause of the injury.
Correct.
But in Robinson, we said it wasn't the proximate cause.
Correct.
All right, so that's what we're trying to figure out here. Tell me why the Robinson doesn't apply here. There was a decision to enter the water. There was negligence, gross negligence on the part of the guard. Why is that the most proximate cause? The gross negligence.
Because it was the last in time to the injury. It presented the last clear chance and opportunity
So
for
was the
someone to
policeman's
intervene.
decision to chase. But it wasn't sufficient in Robinson. Absent the decision to chase, no collision.
Simply because there's going to always be a chain of events, and this was the last meaningful and clear opportunity to intervene. And so it was subsequent to anything else that happened here. That's why it should be found, or at least a question of fact for the jury, because we're only here on a summary disposition posture.
So anytime it's the last in time proximate, even in any case where there are a number of proximate causes, which is generally going to be the case, if it's the last in time proximate cause, that's at least
Generally going to be
possibly
the case.
proximate cause, and we should let a jury decide?
Given that
is that one way
language-
we could give some meat to this standard?
Yes, Justice McCormick, I think given that language from Robinson, that's where you look first, is to the last, most immediate, closest in time temporally to the injury.
Thank you.
Thank you, Your Honor.
You have 1 minute and 45 seconds.
Thank you, Justice Young. What I heard mostly was argument about duty and not proximate cause. And just by way of example, there's an unpublished court, I know you're not that interested in unpublished Court of Appeals opinions, but there's a drowning case, I think it's Glarner versus Okemos Public Schools. And in that case, you had a disabled, an epileptic child who drowned in the pool. And the argument was made, it has to be the gross negligence of the lifeguards that allowed that to happen. In that case, the Court of Appeals found there was no gross negligence because that lifeguard was scanning back and forth. All the evidence was that lifeguard was scanning, there was an immediate rescue, and that child died. And I bring that up for this point. Whether Beals was doing whether Harmon was doing his job or not, it is entirely speculative whether he could have intervened and he could have saved Beals. So because it's entirely speculative, notwithstanding the affidavit of Gerald Dworkin, it can't be the proximate cause. It can't be the one most immediate, efficient, and direct cause. And keep in mind, in
your scenario, what could be? What would it be?
In this case, it was the aspiration of water by Mr. Beals. And whatever that cause is, and we don't have to identify it, whether he had a seizure, whether he had a fainting spell, whether something happened to him, we don't have to identify it. What we do know is it was nothing that Harmon did that caused that harm to happen. And in Dean, keep in mind, there was an affidavit of a firefighter that was far more specific than
But counsel, isn't the water itself, I want to go back to the analogy you made about your child, and I appreciate the analogy that you brought. And you said that in a situation with your child, that it was an aid that induced your child to, that were to be the inducer to go into the water. Isn't water itself the inducement in this situation? If you have a swim class or a swim activity at a program designed for special needs folks, couldn't the water itself or the activity of swimming, in the fact that everyone is participating in the activity, doesn't that in itself serve as an inducement?
It's a voluntary participation on his part. And this
for an autistic person?
And this court has found that people that engage in recreational activities, there's a certain assumption of risk that you take. Everybody knows that swimming is inherent.
A certain assumption of risk for a gentleman with autism?
Well, we don't know the level of the autism now. I think, as I said, there's wide spectrums of what the disabilities. If Mr.
Shouldn't that then be a question for the jury?
No, I don't think that would be a question for the jury whatsoever, because it's not, the proximate cause is a legal question, and that legal question is for this court to decide based on what, you know.
Well, it's a legal question if there's undisputed facts.
Right,
And the record may be undisputed, but again, if there is more than one proximate cause, couldn't that then be a jury submissible issue?
I disagree. I think it's this court in Robinson said it determined as a matter of law what the proximate cause was. If you go back to traditional tort concepts, if you go to Moaning versus Alfano, it is a court decision to decide what, based on what the facts are, which we've got laid out here and they're not in dispute, as to what the proximate cause is.
Counsel, is it your view that a failure to act when there's a legal duty to act can never be the proximate cause as per Robinson?
I think that's conflating, again, duty with proximate cause. I mean, the failure, it's someone breaching their duty. And this court in Helfer versus Centerline Public Schools, where the kid got out of the bus and there were statutory violations by the bus driver in letting that child disembark and cross the road. So that's not the proximate
I know all the cases, and let me ask
cause.
it differently, because I think I understand the difference between duty and proximate cause pretty well, so let me just try and get a little bit more specific. The opposite question of what I asked co-counsel. Can you imagine a case, apart from the hypothetical you gave us about the aide, which seems like an easier one, but where there's just a lifeguard on a stand there are undisputed facts that are a lot uglier than the facts here. Say the lifeguard is completely high, or you give me whatever the worst case scenario is. Can you imagine any case where a lifeguard in a stand can be the proximate cause?
Not under the gross negligence standard. No,
Thank
I
you.
think there may be other avenues of relief. There may be criminal liability.
Counsel, what if the lifeguard, sorry, was one last question.
Sorry,
It's
Justice.
related. What if the lifeguard actually saw the person in distress and decided not to do anything? Under your analysis, under that scenario, could that be the proximate cause?
I don't believe so, not under gross negligence. Again, there may be a different remedy in that case. It might be an intentional tort. It might be a criminal activity.
Well, it would clearly be grossly negligent, because it would go beyond, deliberate indifference to somebody's dying in front of you, right?
Well,
that's not, the question is, in the proximate cause world, once we acknowledge it's a proximate cause, would in that scenario that become the proximate cause of death, as plaintiff's counsel argues, because it's closest in time, and everyone would acknowledge there's an opportunity there clearly to intervene.
If it broke the causal link, there is that possibility. I mean, thankfully we don't have
Counsel, if
that.
that's the law, if what you have just articulated is the rule of law, then how would that work when, for example, that principle is explained in training to lifeguards? So lifeguards, while they're being trained, they can be told, now, just so you know, the law of the state of Michigan is, even if someone is drowning and you're watching, the law is, don't worry, you're going to be protected from suit. I mean, think about the ramifications of the legal principle that you have just espoused.
Right. Well, what I'm suggesting, Your Honor, is that it may not fall into the realm of gross negligence. They may be acting outside the scope of authority. They may not be protected by that statute. And we do have a case. There was a case in Detroit recently where there was, I think someone drowned. I think it was at a high school. And that lifeguard was criminally charged. And so what I'm suggesting is that under these concepts, and this is such an outlier of a fact pattern, that if you had a lifeguard actually sitting there and purposely and intentionally disregarding someone in distress in the pool, which of course we don't have here, then that may be a different situation. And I'm suggesting that it may be analyzed under a different statute, not a negligent statute.
Thank you.
Thank you, Your Honor.
Case is submitted.
Thank you.
We're adjourned.
Okay, that's it.
Please have a seat. My name's Joe Bauman. I'm the general counsel to the Michigan Supreme Court, which means essentially I give them advice on everything not dealing with things like they did today. So I give them advice on ethics and statutory construction on things on the operation of the court. But I'm here today hopefully to moderate what will be a quick conversation and hopefully some questions from the audience. We had a great argument, a very hot bench, as they say, as you heard and were part of, frankly. How about a round of applause for our litigants today? As opposed to the 30 minutes we had originally planned, we're probably only going to have 10 or 12. So if you've got questions, please come up to the mics up front. And until we see somebody, I'll try to keep them talking. So maybe they'll say something else interesting. How many of you had an opinion of the case before today? Okay, a good number of you. How many of you changed your opinion? Oh, we have a couple out there. All right. Maybe I'll start with Appellee's counsel. Could you maybe describe how much you expect to change the opinion of the court in an argument like today, after you've already put in your briefs?
Well, I've been told, because I went to an appellate bench bar conference, that actually oral argument may not necessarily matter all that much. But nonetheless, you prepare in the hopes that you can have some influence and turn one or two of the justices your way that would not have ordinarily been there.
Okay, great. Could you briefly describe the hot bench concept, and whether you like it or not, whether you'd rather just argue for 15 minutes and get back into your seat, or whether you like having the questions like you had?
Great, thanks, Joe. I prefer the hot bench because, as Justice Young pointed out in his prefatory remarks, this has been fully briefed. Obviously there's a written opinion from the Court of Appeals, and then we had to file an application for leave to appeal, which was probably, 25 or 30 pages. And then when the court granted today's oral argument, it asked the parties to then file supplemental briefs. And so we had a pretty singular, discrete issue that we were discussing today. So if you can't say it in 50 pages, then you're not getting to the point. So I don't really feel like there was a lot new that I could say that had not already been in the brief. So I prefer to get the questions so you get a feel or a sense maybe of what's concerning the justices.
Wonderful. We've got looks like some questions. If you'd like to step up and.
I am confused as to why they didn't, as to why he drowned. Because it said in the evidence that his family reported him a strong swimmer. Did he get stuck on something? Did he have a medical condition that prevented him from getting to the top of the water? And if he did, would that change your argument?
Sure, because the issue here is what was the proximate cause, the cause of the drowning, and we have no evidence in the record as to why he drowned. It's speculative. We have an expert report where he indicates perhaps it was what's called a shallow water blackout. There's some suggestion of that in the record, but we don't know. And the posture of the case is such that you view the evidence in the light most favorable to the plaintiff, and so therefore you would view it in favor, I think, of liability to the defendant if there is no evidence in the record. You defer to the defendant's liability as far as what is causative.
Great, thank you.
So how do both, all of you guys up there, how do you justify redefining the definition of this law based on the specifics of, such specifics of a case where things are so circumstantial and where often the hypotheticals went back and forth between stuff very specific to the case versus the general redefinition of that? How do you justify this sort of back and forth schizophrenic system of sorts?
Well, we should have the justices answer that, right? Because we're not asking for a redefinition of the law. And in fact, what we have argued is we are asking for the court to actually apply the plain language of the gross negligence statute coupled with its prior decision in Robinson versus City of Detroit. So that definition is already out there. We're not asking the court to change anything.
Well, in fact, there's a concept called stare decisis. It's the law that exists at the time. And these folks were arguing as to the application of the law, at least generally, to this set of facts. And the court, I believe, would tell you that they don't want it to be a schizophrenic system. They want to have a rule of law that everyone gets to live by. And the facts and the individual things that happen case by case are really very particular and specifically so. And you should, as a citizen of Michigan, want the courts to take those things into account every time. So it may seem schizophrenic, but we'd like everyone to have the same protection. So I hope that answers your question. Move over here.
Okay, so this question goes to Mr. Donnelly. You, towards the end there, you did mention that there was a case in Detroit where a lifeguard was criminally convicted. Is that true? Is there a difference between that case and this case that you were debating today?
I don't know if that lifeguard was criminally convicted. I recall reading in the newspaper, and I think it was in the last 6 months or so, and I'm sorry, my sense of time is not great. But so I don't know if he was convicted or not, and I don't know what the specific facts of that case were. I was just trying to make a point with the court that even if there isn't some kind of remedy or relief under this particular statute, that there might be other avenues of relief available, including a criminal case or maybe some other cause of action against the defendant.
Thank you.
Great, thank you. Yes, please.
When they were exploring the reasons as to why the young man drowned, why wasn't there any conversation about an autopsy?
Well, there was an autopsy, and the autopsy merely concluded that he died of drowning and that the cause of death was accidental, so that wasn't really much to be discussed. There wasn't any indication of some sort of an underlying health issue or a seizure or anything like that that would have caused him to submerge underwater. And so because you're left with like a blank page there, again, that's, I think, favorable to the plaintiff, the non-movement, because you view the evidence in the light most favorable to them and make reasonable inferences in the plaintiff's favor. So in the absence of something else to point to as the proximate cause, you can point to the gross negligence of the lifeguard.
Thank you. Please.
My question is regarding whether, or what Justice Kelly said at the end of the arguments. Well, she said that if the defendant got his way, that no mistake made during duty would go charged. But wouldn't the converse also be true of if you make a mistake, that you can there's no legal help for you, no defense for you, and wouldn't that make nobody be a lifeguard?
It's a very interesting question. Good one. And we'll switch sides on it, see what plaintiff's counsel has to say.
I'm sorry. Would you mind repeating that real quickly?
Well, Justice Kelly said that if you do make a mistake, she said that if the defendant got his way, that if you do make a mistake,
right,
you could never be charged with gross negligence and be found the proximate cause.
Right.
But if you, Mr. Plaintiff's counsel, got your way, that every gross negligence suit would go plaintiff way.
Well, I'm advocating for my client, and if we have somebody who's drowned, I'd like to recover for them. But every case is going to has its own facts, and every case is going to go through an analysis of this 1407 Government Tort Liability Act immunity analysis, where you have to show that the government actor was acting in the course of or scope of their employment, and that their conduct was grossly negligent, and that it was the proximate cause of the injury. And each of those steps has to be met in order for you to survive governmental immunity and then survive summary disposition and then go forward to a jury trial. So it depends on the facts.
As you expected him to say, right?
This question's for the defense. You said near the end that the actual proximate cause doesn't quite matter as long as the gross negligence of the lifeguard isn't it. And I was just wondering for clarification, by that argument, how do you, I mean, if you can't think of a cause greater than that of the lifeguard's negligence, how do you argue that by default the negligence isn't the proximate cause? Disregarding the argument of water, just like hypothetically, if you can't definitively present a greater proximate cause, how can you defend that the gross negligence isn't that?
That's a good question. And we are saying that the greater proximate cause was just the mere act of Mr. Beals going swimming on his own volition, diving underwater, and whatever happened, we know something happened to him. We don't have to prove, it's not our responsibility to prove what happened. So whether he had a fainting spell, whether he tried to hold his breath for as long as he could underwater, whatever it was that caused him to stay underwater, that's the proximate cause. That's what caused him to drown. Because as I tried to point out to the court, even had Mr. Harmon been doing everything exactly right, he's scanning the pool left and right, he's paying attention as best he can to all 25 people, there's no guarantee that he ever would have seen him. None whatsoever. None of the other 25 swimmers in the pool saw him. And so the point is that if you can't say what he did caused it, then he can't be held as the one thing more than any other that's responsible for the death. And I know some people might think that that's a really harsh result, right? So, and don't get me wrong that I'm dispassionate about, you know, the well-being of other people, but the legislature, and this didn't come up, I thought it might during the argument, but the legislature has made a public policy to limit liability against the government and governmental actors. In the old days, it was under the kind of the antiquated notion that the king can do no wrong, right? And so you can't sue the king. But I think now the practical reality is that the king does do wrong, and the king does wrong a lot. And so you can't, the legislature has made a policy that you can't hold the state and thus the taxpayers liable for every injury that befalls somebody because of the alleged misconduct. So they've set the bars really high. Not only do you have to engage in grossly negligent conduct, but that has to be the one thing above all that caused the injury.
Thank you. We're going to take, I'm very sorry, we're going to take one more question because I know the justices, once they get out of conference, are going to want to have some time with you at the reception. So I'll take one more from this side.
Oh, shit. Okay, they can go first because I have like 3 questions in my mind right now.
Okay, we'll take the last one from over here then.
Why wasn't his disability considered to be a proximate cause?
Why wasn't his disability determined to be a proximal cause?
Well, the only disability for which there's any evidence in the record at all was that he had a learning disability and some form of autism, and there was no indication that it was the sort of disability that would affect his ability to swim, and in fact there's evidence in the record that he was actually a competent swimmer. So it really wasn't relevant to the inquiry. So, thank you.
All right, thank you everybody. I think everybody's going to go up through these doors. Thank you. And the court will meet you out there, so I follow everybody else that direction.